I have Commissioner Krakenbull, Commissioner Evans, Mr. Ritter, Mr. Fuller, Doug Chalmers, Mr. Lane, Ms. Wetzel, Mr. Becker, Mr. Salzer, Mr. Russo, Ms. Anderson, Mr. Dove, Mr. Thompson. Is there anyone else on the line?
Yes, you have Ben Keene from Denton.
Go ahead, please, sir.
You have Ben Keene from Denton.
I'm sorry, say that again.
Ben Keene from Denton.
Okay. Anyone else? Okay. All right. It is officially 10:05 a.m. and we will go ahead and call this specially called meeting to order. The only business that we have today is to go over and discuss the and either adopt the advisory opinion 2017-05 or not. So I believe that to start, we had it was brought to us by Mr. Chalmers, and at his request, he was seeking the advisory opinion. So I believe because it was his request that he, if I'm correct, Mr. Ritter has the floor to speak first, and then you get to present, correct?
Well, I actually think that we should present the advisory opinion, and then if Mr. Chalmers has comments on it, welcome that. It's not an adversarial matter.
Right.
Rather, it's an opinion that's being issued by us. So, of course, if you'd like for him to speak first, that's fine, of course.
Do any of the other commissioners want to hear from Mr. Chalmers first or Mr. Ritter first?
Hey,
Doesn't matter.
it's fine with me, whichever way you want to go.
Okay.
Madam Chairman, this is Doug Chalmers. I have no comments initially. I'm fine to have Stephan present.
Okay. All right. Thank you, Mr. Chalmers. Okay, go ahead, Mr. Ritter.
Thank you very much. Again, since we're on the phone, let me just say my name is Stephan Ritter. I'm the Executive Secretary of the Georgia Government Transparency and Campaign Finance Commission. And before the Commission is a proposed advisory opinion number 2017-05 that responds to 5 specific questions that were asked by Mr. Chalmers. Before discussing the substance of the opinion, I think it would be helpful to very briefly review some of the procedure in front of us in terms of advisory opinions, what we're considering here, and what the role of the Commission is in issuing such an advisory opinion. In my understanding, our Commission is the only agency in Georgia that has the authority to issue an advisory opinion on hypothetical facts. Of course, the Attorney General's office, separate constitutional officer, can do that generally on request from the executive branch, and sometimes with the legislature or local governments can ask for those from the AG. And occasionally other agencies have issues that are submitted on contested matters or matters that are concrete facts, but we're answering hypothetical facts here. In our view, in reviewing such a set of questions, we are not attempting to legislate or create new law in any way. Rather, I think that the role of the Commission in answering advisory opinions is to try to stay within the 4 corners of the law as it's written and determine how it would apply that law to the hypothetical facts, which are, of course, speculative because they haven't actually occurred yet to the best of my knowledge. Let me emphasize that in doing that, in not legislating, we are writing an opinion that is attempting to be narrow and not trying to answer every possible question that could arise, because frankly, many questions are going to arise when we see specific facts, and trying to guess at those without seeing the full quantum of set of facts, it could lead to error and serious problems. Nonetheless, as I discuss this advisory opinion today, and I'm going to keep my comments within the 20-minute time frame, not including answering questions, I will tell you that I will address a few issues that I think are not within the written opinion, but are things that might be implied or not implied by the opinion. And some of those, I think, have been raised by the one letter that we've received in response to the proposed opinion from the Robbins Law Firm. And they raised several questions. Of course, I want them to be able to address their questions separately, but I will mention a couple things about their questions as I go through my presentation. Okay, so having said that...
Stephen?
Yes, sir.
This is Dennis, Kathy. I am on. I've been on a while, and I don't think anybody maybe didn't realize it or didn't care, but I'm on the line.
Okay, we were wondering where you were, Mr. Kathy. It's great to have you here, and I know
I'm present. I was distracted by my day job for a moment, but I'm here.
Okay, I will continue to push forward, and of course, let me emphasize to the commissioners that I don't mean to preclude questions in the middle of my presentation. Just please speak up should you have any questions to ask, and of course, at the end of my presentation, I'm happy to take more questions then. All right, so we received 5 questions from Mr. Chalmers, and I'm going to paraphrase those questions to an extent. The first question asked whether a candidate or his or her agents directly or indirectly establish, operate, or solicit funds from a nonprofit corporation or other entity to make expenditures for public communications that will reference the candidate or the candidate's opponents if those communications are an express advocacy. And let me discuss that as an initial matter. In considering that question, as a note in the opinion, and I want to emphasize this, on the one hand, we're considering these are not express advocacy. The definition of an independent committee under Georgia law requires express advocacy as interpreted in our regulations. So, strictly speaking, in answering this question, we're not considering an independent committee. On the other hand, if communications are referencing the candidate or the candidate's opponents, it is hard under Georgia law for that not to become something, I think, currently that would get close to express advocacy. The fact of the matter is that there may be some narrow body of area where such communications are not express advocacy, and so it would not be a independent committee. If it's not an independent committee, then there are 2 possibilities for such an organization outside of it being just the candidates committee. One is that this outside organization is a PAC, and in that sense, the PAC under Georgia law is making contributions directly to the candidate. And in that sense, an in-kind contribution would be considered to be a contribution to the candidate. The other option is that it's possible that this is some sort of issue advocacy, which is completely independent of the campaign. However, if it's issue advocacy, it's very unlikely that it would be making reference to the candidate or the candidate's opponent. But let me take a moment to discuss issue advocacy for a second and discuss what that is and is not. Georgia doesn't have a law that relates specifically to issue advocacy organizations that are outside of the scope of independent committees or PACs or the candidates committee. So if it were purely an issue advocacy organization, and therefore very likely one that's not talking about the candidate or the candidate's opponent, so it's not engaging in express advocacy, but it's advocating on some issue, that's outside of the scope of this question. We're not addressing whether an issue advocacy organization would be one covered by this question or not. So if a candidate establishes or contributes to an issue advocacy organization, one that's completely outside of this question, not answering the question today, whether that issue advocacy organization would be covered. And I can tell you that there's a decent argument that it would not be covered under this type of situation. However, that brings us to the line of how do we draw that distinction between issue advocacy and where it is engaging in advocacy for the candidate. In the moment, I haven't gotten into the issue of coordination, but let me just say that when we talk about where that line is, we have to use the phrase that Georgia law currently does use in terms of its regulations, which is engaging in express advocacy. And as you know, in the past, last in 2010, there were two, in 2001 and in 2010, there were two advisory opinions that were issued by the Commission to try to discuss what the meaning is of express advocacy. And what they did is they adopted the rule from Buckley versus Vallejo. While we have made several factually correct statements about the status of that, because the Buckley versus Vallejo rule, which may have been a good rule at the time the initial opinion was issued, is a rule that is no longer followed in terms of federal constitutional law. It is still arguably the rule in Georgia because of those AOs. I can tell you that we are not attempting to answer the question in this opinion, one way or the other, whether these AOs remain good law. I think it's outside the scope of the questions asked to determine whether the express advocacy rules from those AOs are in fact good law. I will also say that we anticipate that we will propose a regulation to address the express advocacy phrase. And what I will recommend for such a regulation is that we have a hybrid test, much like the federal test, which both uses the McConnell rule for express advocacy, which is the magic words test, which is currently sort of in the federal regulation, and then also uses what's been called the functional test, which looks at the actual function of the way that express advocacy occurs. We could also define electioneering communications, which we do not currently under Georgia law, to help narrow this issue. However, at the present time, the proposed AO does not comment in terms of the validity of the prior AOs. And I will emphasize one more time on that. An argument could be made that the underlying basis for those AOs is no longer good, and that's probably true. But nonetheless, the AOs remain on the books. So we would not expect people to willfully disregard those AOs at the current time, nor do we think, given that they're on the books, that the role of this AO would be to throw those out the door if we can avoid doing that. And I don't think we need to answer the question about whether those AOs are good or not in answering the questions presented. So that brings us back to the
Stephen, this is,
yes, sir.
This is Mary Page. So it sounds like what you're saying is that, and in reading the footnote of the AO, that the express advocacy standard that is currently on the books for us is not necessarily the standard that is utilized in the federal system, correct?
It is not, and that's also not the standard that's used in most states. Most states, even states that did in fact follow Buckley, immediately retreated from Buckley when Buckley was superseded by the McConnell case. And I may have said
okay.
Okay, so it's the Buckley standard that we currently follow. Buckley magic words.
All right. So my next question is, though, in going back and rereading Mr. Chalmers' question, though, I don't, hang on, I've got the wrong, wait a minute. So my question is, then his question number 4 asks about express advocacy. And so what you're proposing is that because those 2 AOs have not been overturned and Georgia doesn't have a statute on express advocacy, that we still need to rely on those 2 AOs from 2001 and 2010, correct?
Well, let me answer it like this. First of all, I will address 4 when I get there, and I'm focusing on 1 at the moment. However, I think that it is arguable that those 2 AOs are still on the books such as they are, and while we could just say, the commission could say that it, overrules those AOs or whatever appropriate language you'd like to, I don't think you need to go there. And in the attitude of writing an opinion that's conservative on the law and doesn't do more than it's necessary, I don't think it's actually necessary to answer these questions by saying exactly what express advocacy is and is not today. In fact, I think it's better, and I'll address that when I get to 4, but let me say this. I think the better appropriate way to address the question of express advocacy itself, what it is and what it is not within the boundary of this complex opinion, but rather is to do it expressly by regulation. Because that's a term of art that requires definition, and the appropriate way to define it is not by an AO, in my view, but by a regulation that says this is what express advocacy is. So we will propose an express advocacy regulation, and what I anticipate, although we have to discuss it internally, is that we will propose a regulation that is similar to the federal regulation on express advocacy. It's not only neat to make them parallel each other, but I think that it's more or less workable regulation that most people understand to the extent those things can be understood. And that addresses actually the first concern that the Robbins Law Firm had, because I think they're implying that we're getting rid of the express advocacy definition. I don't think that's true, but I don't think we're answering the question either. That's where we are on that. Let me pick that up when I get to 4, if I may, ma'am.
Okay, sure. I just want to make sure that I want to make sure that we are not getting ourselves in a situation where the egg comes before the chicken. I mean, if we're going to eventually do a reg on express advocacy, then how do we have an AO that talks about express advocacy?
Well, the definition, right. The AO in this case uses the phrase express advocacy, but doesn't say specifically what that express advocacy is, because it's not necessary to define the 4 corners of express advocacy and trying to answer the questions presented.
Okay. That clarifies. Okay.
Thank you. Okay, so coming back to number 1, and the question is, can they establish, through their agents or otherwise, or operate, or solicit funds for this nonprofit or other entity that's going to reference them, but it's not express advocacy, so it's not an independent committee. And if it is going to reference them, and they are going to be, in a sense, coordinating to create this organization, then the question is going to be, essentially, and to cut it to the nub, can a candidate have more than one campaign committee? And here's why that's the question. Georgia law already provides for an organization that is not the candidate per se to function on the candidate's behalf, and that is the candidate's committee. It's required to have a separate bank account. The candidate doesn't have to have a committee, but if a candidate does choose to have a committee, the candidate has an organization acting on the candidate's behalf. In doing that, it seems fairly clear to me that the code has presumed that there is one candidate committee. Candidate, in other words, can't have multiple different types of committees acting on the candidate's behalf. Indeed, the code has specific reporting requirements for the candidate or the candidate's committee and attempts to regulate how how that organization is to report in terms of receiving donations and expenditure of donations. If we were to say that a candidate can have not only a candidate committee but can have other external organizations, then obviously the candidate committee becomes essentially pointless. And the regulation of the candidate committee is pointless because all of that stuff can be done outside of the candidate committee, and the reporting by the candidate committee has no point whatsoever because it would be impossible to track the funds that are being spent for certain types of activities or contributions from third parties to those entities, since there'd be no reporting requirement if they're not a PAC and if they're not an independent committee, but essentially are functioning as some sort of other organization that, in my view, essentially takes the place of a candidate committee. So to get to the chase, when he asks, may a candidate or his agents directly or indirectly establish, operate, or solicit funds for a nonprofit corporation or other entity that will make expenditures? Well, there is such an entity right now. That's the candidate committee. And there is no provision to have another organization other than the candidate committee that the candidate is doing that for under Georgia law. So the answer to that question, in short, is no. You can't do that. However, having said that, let's be clear about what we're talking about. We're referring to a candidate. So that's someone who, in terms of the Campaign Finance Act, is already someone who has begun to either solicit funds or expend funds for a campaign. We're also referring to an organization that will reference the candidate or that candidate's opponent. So let's take the first one. Suppose that someone wants to be a candidate at some time in the future, but hasn't decided to do that yet, or specifically may have engaged in the preliminary activity that this commission in the past has said is okay, but is not actually expending funds for the campaign or soliciting funds for the campaign. In that instance where the person is not a candidate, that type of activity, creating such a third-party organization, would be okay. In fact, under federal law, it is a commonplace now, and I think the boundaries of this are yet to be finally determined, but it is a commonplace now, particularly on major national campaigns such as that for the president, for people who anticipate they will become candidates but have yet to actually function as candidates, to create organizations that ultimately might be what the feds would refer to as super PACs or other types of organizations, not PACs under Georgia law, since they're not contributing to the candidate. It's important to understand, by the way, without trying to get lost in the weeds, that what federal law uses as a PAC, at least in the general sense, and what we use as PAC are not necessarily the same thing. For instance, a super PAC typically is something that does not contribute to a candidate directly. Rather, they're more in the terms of issue advocacy type of organization. So they would not be PACs under our law in many instances. Nonetheless, those types of organizations may be created before someone becomes a candidate. And once the candidate becomes formally a candidate, there is no coordination. And that non-coordination, separation of their activities, currently under federal law, seems to be okay. There's certainly clarification the feds might engage in. I think the same rule would probably apply in Georgia on the four corners of our law, which is to say that candidates or people who think they might be a candidate but still create an issue organization without having taken the steps to become a candidate can create those issue type organizations. And once they become a candidate, they separate. There is no coordination. So at that point, they're not establishing or directing once they're a candidate. They're not operating. They're not soliciting funds for that organization. That organization now functions separate. The reality is that we know that those organizations will look to the candidate and see what the candidate is doing They may look to prior activities of the person before they were a candidate and see, to grab sound bites or other things from that. And currently under federal law, that's okay, and it seems to be likely that that will be upheld. I'll give you some examples from the federal election for president. Candidates for federal election, before they become candidates, often create something called B-roll, which is stuff that they might use in an ad, but they're not sure. And then they end up like posting it to YouTube. And then the super PACs come and they scrape the B-roll and they do stuff with that, but there is no coordination in doing that once someone becomes a candidate. So the candidate functions separately, but the B-roll is out there, and they know or should know that the B-roll would probably be used to for ads that might support their campaign, but there is no coordination. They're not soliciting funds. In that instance, if the organizations are completely separate and uncoordinated, it seems to be okay under federal law, and that is not addressed, but I can tell you is not forbidden by the draft opinion that we have prepared. The other situations that I should briefly mention are things that are non-political types of activities by outside nonprofits, which are, things in the federal law referred to sometimes as leadership PACs. And we dealt with those recently in dealing with the Cesar Mitchell case, but in part. But if those leadership PACs are outside the scope of political activity, then engaging activity that is not, or that is soliciting funds for that leadership PAC or being involved in that leadership PAC is probably okay. But that's not asked by this question, since it asks for communications that reference the candidate or the candidate's opponent in an election. So leadership PAC is outside of the scope of that question, but I can tell you this proposed opinion does not frown on leadership PACs that are completely non-political. So again, we think that the correct answer to question number 1 is no, within the framework of the way the question's been answered, which is because, to get to the chase of this whole question, a candidate can only have a candidate committee. And by providing only for a candidate committee and for reporting by that candidate committee, it would be nonsensical and indeed contrary to the purposes and structure of the law for external organizations still to be able to politic on behalf of a candidate that are coordinated with the candidate. Let me then move to question number 2, which asks whether that... Yes, ma'am.
Stephen, before you do that, let me see if any of the commissioners have any questions on number 1.
This is Dennis. I do not.
Yeah, this is Jake. No questions.
Yeah, and this is Jamie. I don't have any questions at this time either.
Okay, great. And you answered my question. So, okay, thank you, Stephen. Go ahead and move on to number 2.
Okay, Madam Chair. Number 2 asks whether the question to 1 would be changed if it was a 527 organization under the Internal Revenue Code, which, although we don't have 527 organizations under Georgia's revenue code, an organization that was established for the purpose of influencing elections. Would that change the answer to the question? And the answer is no, it would not. Not only do we not have 527s, but the fact of the matter is, if it was established for the purpose of influencing elections, then we would think that in that instance, such an organization is either, if it's the candidate who's coordinating with it, then it is the candidate's campaign committee, and it's not an external organization in that sense. Or it's not okay for the coordination to occur within the scope of the question that's been asked. So no, I don't think the answer changes if it's a 527. I will say, just for reference, that this does imply, but we do not address the question here, issues about what are so-called dark money. And what's typically meant by dark money is money that can't be traced to the actual source. And the way that frankly happens at the federal level is that individuals create a 501c4 usually, which is an organization that can participate in the political process, but that's not their primary purpose. And the donors are not disclosed to that 501c4. And the 501c4 contributes to a 527. And the 527 is required to disclose its donors and engages in explicit political activity. So what happens is, since you can't go back behind the 501c4, you don't actually know who the donors were in terms of individuals. That's not our problem. We are not answering a dark money question here, but I don't think the answer to number 1 changes by number 2. I'm ready to move to number 3, ma'am, unless you want to ask for questions again.
Any commissioners have any questions? Okay, go ahead and go to 3.
Okay, thank you very much. Okay, number 3, if a candidate and or his agent solicit contributions to the type of entity described in 1, are such contributions regulated or limited by the act or the rules? Well, let me say, if that organization is a properly, lawfully created campaign committee, which the law does call for, and which would be in the scope of question number 1, then yes, we do regulate that. And of course, and the answer is you have to file the appropriate CCDRs as well as registration with our commission. And that's exactly what the Act calls for, so it's regulated. To the extent, however, that such an organization would be created that's not a campaign committee, well, there's no provision in the Act to regulate them, and that's just the problem. The Act contemplates one organization, the campaign committee. In that instance, we think that question number 1, if we're not a campaign committee, in fact, well, the answer would be you can't create it in the coordinated sense, and so that would create the question of how it's prosecuted, which is not within the 4 corners of this Act, but I can tell you it would not be permissible, in my view, to have such an organization because it is covered, if it is lawful, by being a campaign committee. And then let me move on to number 4 if you're ready.
Yes, please.
Okay, in number 4, the question is, may a candidate and or his agents coordinate as that concept is applied in the rules with an entity of the type described in number 1 on expenditures for public communications that will reference the candidate or the candidate's opponents in an election if those communications do not contain express advocacy. In other words, may a candidate or candidate suggest such an entity make such expenditures or cooperate or consult with the entity with respect to the expenditures. If such expenditures are coordinated in such a way with the candidate and his agents, are such expenditures regulated or limited by the Act or the rules? So this brings me back to the question of coordination, and we could talk about express advocacy, but first let me talk about in-kind contributions. So one of the fundamental distinctions between a PAC and an independent committee is that an independent committee engages in express advocacy, but is not coordinated. And in fact, we have a regulation that deals with that explicitly, referring to independent communications. And it says, and we've already regulated this, it must not be made with the cooperation or consent of or in consultation with or at the request or suggestion of any candidate or any of his agents or authorized committees. An expenditure which does not meet the above criteria for independence is considered a contribution which is subject to limits. I didn't highlight that part, but that last part is important. And here's why that's consistent throughout the way the code is written and the way this commission in the past has interpreted regulations and in cases. That's because if a communication is made in coordination with the candidate, in most instances, that type of regulation or that type of communication is going to have been a type of in-kind communication or in-kind contribution, so since it will have been made on the candidate's behalf at the candidate's request. If it is not solicited by the candidate and it is something that is express advocacy, it's not cooperated, it's not coordinated with the candidate, then it would fall within the meaning of an independent committee. If it is coordinated, and it is not by an organization created by the candidate, then in that instance, it would be an in-kind contribution. If it's in an organization that's actually created by the candidate, then in that instance, it's probably run afoul of the fact that you have to conduct those communications if you're a candidate through your campaign committee, if you wish to have one. So such a contribution would be treated as, or statement, excuse me, such a communication would be treated as an in-kind contribution to the candidate. And as such, it should be reported on the candidate CCDR, the candidate's aware of it, and it should be if it's in coordination. And if the contributor has spent more than $25,000 on those types of communications, then it's also going to have to be a PAC, which is going to have to register and file with us as a contributor over $25,000. So here, again, I have not answered specifically what we mean by express advocacy, nor is it necessary to do that. We can answer that question whether the Commission wishes to reaffirm the Buckley rule or wishes to have a more modern test that I think if we follow the FBC is sort of Buckley and sort of functional. But in any respects, we don't need to change the four corners of this opinion because express advocacy will only determine whether it's an independent committee, and if it's not coordinated express advocacy, then it's going to be an independent committee. If it's coordinated express advocacy, it's either going to be a PAC or it's going to be by an organization that the candidate is so bound with that the candidate, in that instance, should only have done it through their campaign committee. Bottom line is, in my view, if you solicit communications, then we're covered by the regulation. Our regulation said it must be, that is the communication, to be an independent communication, must be made or must not be made with the cooperation or consent of or in consultation with or at the request or suggestion of any candidate or his or her agents or authorized committees. In that instance, if it doesn't meet that, then it is considered a contribution under the express terms of our regulation. And therefore, you know, the candidate would have to properly report it, and that's how we address it already within the four corners of our rule. So the answer to is, there are actually several questions on 4. The answer is, if such a suggestion is made, then it's going to be, in all likelihood, a contribution. And then there's going to be a question about independence, but at a minimum, it will be covered by our regulations in terms of reporting as a contribution. And that reporting is done by the candidate unless it's over $25,000. And in terms of creating an organization to make those, we've already covered those in number 1. The only organization that the candidate can create by law is the candidate committee. And I'm ready to move to 5 unless there are questions on that.
Okay, any questions by any of the commissioners?
No, ma'am.
Okay, all right, go ahead, 7, move on to number 5, please.
Thank you, Madam Chair. Number 5, may a candidate and or his agents establish, I think probably gone over time, establish, create, and or solicit contributions for an independent committee that will make expenditures for communications that expressly advocate the election of that candidate if neither the candidate nor his agents coordinate with the independent committee on the expenditures themselves. Again, I note at the beginning of 5 that if we're talking about someone who's considering becoming a candidate but hasn't crossed the threshold where they have to register with our commission, then doing this is probably fine. And that's consistent with the way that federal law, or at least the way that federal law is generally read right now by most candidates in their, or potential candidates in their committees. That is, they coordinate before they become candidates. After they become candidates, there's a non-coordination rule, and there is no coordination. So after the fact of becoming a candidate, if the candidate then makes suggestions that are essentially electioneering suggestions to this outside organization, then there is coordination. And in such an instance, we would view that coordination as per se with the cooperation or consent of, or at the suggestion of, the candidate that is within the four corners of the regulation that already exists, which is 189-3, or 189-3-.01F, which expressly says that those are treated as contributions. And in that instance, even if an organization was created as an independent committee, at that point it started to function as a PAC. Let me briefly comment on that as well. So this came up at our last meeting 2 weeks ago, and I don't want to answer the question today about whether an organization can be both a PAC and an independent committee, because I think that that's something that needs to be separately addressed by regulation, nor is it necessary, again, to answer that question to issue this advisory opinion. But I'll offer a couple thoughts on that, just so you know where I think we're going. It is a commonplace, both in Georgia and in other states and in the federal level, for a single organization, typically a nonprofit, that's been created once, to have separate bank accounts and separately function for some purposes as an independent committee and for other purposes as a PAC. And that's consistent, in my view, with our statute that was pointed out at the last meeting, because we look at the activity for specific activities as to whether it's an independent committee or a PAC, rather than looking at the overall organization. So it is possible, and there are many instances, where an organization will transform itself from one to the other for some purpose, and the reporting requirements that are going to follow that are going to depend on the type of activity that it engages in. So it may have contributions that go into one bank account where the donors will be disclosed and there'll be an independent committee type contributions, and other contributions where they'll be in PAC bank account. And we sort that out on a case-by-case basis. However, we don't have to answer that question today. And it would be reasonable and appropriate if the commission wanted to say that if you say you're a PAC, then you're a PAC. Unless you do something that violates, then you become an independent committee for all purposes, or vice versa. But that would be very difficult to administer and to regulate, nor is that the way that many organizations function right now in Georgia. So anyway, having said that, that I think answers question number 5. Happy to take questions on that, and then I have a couple very brief final comments.
Okay, do any commissioners have any questions for Mr. Ritter?
This is Jamie. I don't have any questions.
Dennis, neither do I.
Yeah, Jake, I don't either. I would like to hear if anyone else has comments, but no questions right now.
And the same for me too. I don't have any questions at the moment. I got my one question answered that had been bothering me. But yes, if you want to do your closing comments now, Mr. Ritter, and then if anybody else has comments, then we'll let them speak at that point.
Okay, thank you very much.
This is Jamie. Stephan, let me go ahead and ask one thing real quick, just to make sure I'm clear on this. With regard to any of the 5 questions, do you feel like anything in this advisory opinion is beyond the questions that Mr. Chalmers actually asked you to answer?
No, I don't. And in fact, we tried to limit it. As you can see, I think there are a lot of lingering questions out there. Of course, the commission could freely opine on all sorts of things, but we're trying to keep it narrow within the 4 corners of what's been asked. So I have speculated, again, where things might go in terms of we need a better definition of express advocacy, or else to say, no, we're following Buckley, that's fine. If that's what the commission says, of course, that will be the case. And I would say there are also other questions like, what is the, ability of an organization to be both an independent committee and a PAC? All those types of questions could be answered at a later date, but I don't think you need to answer those questions. So we've tried to keep this appropriately narrow and driven by statutes and regulations that exist.
Okay, very good. Thank you.
Okay, thank you. Very brief final comments, and I know I've gone over time, and I appreciate your indulgence. So to briefly say, this is an important issue because it is something that seems to be going on right now. It might have been possible to deal with it as a complaint rather than as an advisory opinion, but we want to make sure that everybody is on the same page to the extent that we can in answering these questions. If you want to make changes to this advisory opinion, that is certainly your authority to do so, within your authority to do so. And I say, if you do that, you need to tell us what those are. I would suggest right now up front that if you do that, the best methodology is to approve the opinion with those changes made and delegate the authority to the chair to review the draft advisory opinion, and if it meets the changes that are called for, then to execute it, and that will allow us to avoid having to have another specially called meeting. However, we'll proceed as you direct. And again, happy to answer any questions. To recap, the answer to number 1, as written, is no. The answer to number 2 is no. The answer to number 3 is yes, to the extent it's a campaign committee, and otherwise you're not allowed to do that. The answer to number 4 is sort of no. It depends on the type of organization that's created, but then there are reporting requirements because they're treated as contributions in many instances. And the answer to number 5 is no. So thank you very much.
Okay, does anyone else have any comments? Okay, all right, so, sorry, does somebody have a comment? Okay, hearing no comments, then at this point, then I think we need to, and Mr. Ritter, you can guide us a little bit on, I know we've adopted these AOs in the past, but at this point, we need to have a motion and a second to adopt it, correct?
Yes, and then after the motion and the second, there is typically a period for discussion if anybody that is in the commission wishes to discuss it further, and then a vote. Right. Since there were no questions,
Okay.
I don't know if it can be a discussion.
Sorry, I do have one comment. Sorry to interrupt. I apologize. This is Ben Keene at Denton's. I just have one question, Madam Chair, and for Mr. Ritter as well, if you'd indulge me for a second. Just want to get some clarification on the interpretation of the coordination standard, or that's being discussed in the in the AO at present. If there's a minute to ask that.
Sure.
Sure. Mr. Ritter, I just wanted to get a little clarification on the AO's description and discussion of the solicitation piece of the puzzle with regard to coordination, fundraising by candidates for nonprofit organizations that may conduct independent expenditure activities in the future. I mean, as you're aware, at the federal level, the definition of coordination and coordination speaks only to the actual making of the communication or the expenditure, and not to the solicitation and fundraising of funds for organizations. And I think that's consistent across the board in nearly all states. If you look at your chart that you guys provided to the commission, I think that's consistent. And I wonder if the language of your AO at present leaves that a little bit unclear, or I guess I'm looking for a little bit more direction as to your thoughts, the commission's thoughts on that issue as it relates vis-a-vis this AO.
Okay, so I have 2 thoughts about that, if I may, Madam Chair.
Sure.
Yes, please go ahead.
Yeah, thank you. So I would certainly appreciate that you would ask for more guidance on what the meaning of coordination is. But I think that if the commission were to do that in writing in this opinion, it's going beyond the four corners of the questions asked. And although we don't desire to leave people in the dark, we need a more specific fact pattern that you're going to give us specifically, is this coordination or not? Ask it in a concrete way if you want to ask that question. But right now, let me say that when we talk about coordination, I think the best guidance that we have under Georgia law is actually in our regulations already. And then again, turning to 189-3-.01F. And it says, it must not be made with the cooperation or consent of or in consultation with or at the request or suggestion of any candidate or any of his or her agents or authorized committees. So, you know, that is perhaps broader in terms of the definition of coordination than federal law currently is. And if you think that there is conduct that should not be coordination but is covered by that, then I think you should ask a specific concrete question the commission can ask on that, and we provide it. But I don't think that answering it within the four corners of this advisory opinion is appropriate, because that's not necessary to answer this question, and we're really getting way out in speculation land without concrete facts.
Okay, anyone else have any comments? Okay, so hearing none, then at this time, then do any commissioners have a motion?
Yeah, this is Jamie. I'll move that we adopt the AO as drafted.
This is Dennis. I second.
Okay, any discussion among the commissioners? Okay, hearing none, then all in favor?
Aye.
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 Okay, all opposed, like sign. Okay, so AO number 2017-05 has been approved. And that is all that we have on the agenda, unless there's any public comment that anybody else in the public would like to make at this time.
We have one person on the list to make a public comment.
That's right, and that's Mr. Becker, correct?
Yes.
Okay. Go ahead.
You'll be able to hear me?
Yes, we can.
Okay. Good morning, Commission. My name is Tim Becker, and I'm a citizen of Milton, Georgia. And just by way of background, I started my career out as a nuclear submarine officer and served this country for 7.5 years. I was a partner with the management consulting firm Accenture, and I'm currently an owner of a successful consulting business for the last 14 years. I've worked with many dozens of clients, including clients you would know like John Deere and Walmart. I know the characteristics of a good process. 22 months ago, I saw misbehavior and corruption in Milton City Council. I saw arrogance, indifference, and entitlement. I decided that I could not sit on the bench anymore. I enlisted the help of other citizens. I created an entity called the Milton Coalition. We fought an ordinance and a rezoning, and the group disbanded in the summer of 2016. I continued to blog and also organize citizen opposition. I've spoken many, many times before our city council. I do have a complaint before the commission. I know it would be inappropriate to speak to that complaint, so I will not do that today, other than to say that I spent $99 to upgrade my blog, and my complaint has been before the commission for 2.5 months. I have not gotten an answer yet relative to this matter. I do believe that your process needs some improvement and that there could be some constitutional issues, but I am not an expert by any stretch of the imagination. My comments do mostly pertain to independent committees simply because that's what I know about in terms of reading the law. I would suggest a few things. That the issue that I have with the commission is it seems like all complaints go through, that there aren't any filters. And that has implications for somebody who's on the business end of these complaints. You're in limbo for quite a while. Maybe you have to hire expensive attorneys. And I can tell you, you get smeared in the public square. And that has happened to me, okay? What's going on right now, and it upsets me, is they're out there, 3 city council members saying he's under investigation, okay? And this has gone on for 2 months. It's disrupted my family life, and it's over something very small. So I think that the commission should consider a threshold of spending. Because the way that I look at this right now, my neighbor and I could get together and say, you know what, we're against a certain candidate. We could go out and buy a sign, a $10 sign. He gives me $5 for that sign. I'm an independent commission. That's problematic for me. And maybe I'm misunderstanding the law, but that seems to be the law. I think that there needs to be some triage that occurs when complaints come to the commission. So just taking an independent committee as an example, does the complainant provide evidence to meet? The definition is fairly simple. I've looked at the definition. Have they provided evidence to substantiate their claims or not? If they haven't, then it seems like that complaint shouldn't go to somebody. It's scary to get one of these letters when you see the word prosecute in it, okay? I also think that there needs to be some distinction between local and state. Certainly at the state level, people should know what they're doing, but I'm telling you, at a local level, they're not aware of these sorts of laws. They're just not, at the local level is where we're going to get our future elected officials. And if we scare people off because of the complexity of our law and not having a threshold and not triaging complaints, that's not a good thing for our political process. And in terms of due process, I think when you send something like this to somebody, I think you need to tell them what the steps are and maybe give them some kind of sense as to when their matter is going to be resolved, okay? It's going to be by October 1st or September 15th or something like that. Because as you know, justice delayed is justice denied. And we hear that many times. It's a cliche, but I believe it. It's painful being in limbo. It's painful when people tell you that you're under investigation. I've served this country for 7.5 years. I believe in this country. I volunteered to serve for this country. I believe in the Constitution. I believe in free speech. And then the last thing I want to say to the commission is, and I think you ought to have standards for your process, by the way, that something ought to get resolved in 4 weeks or something, but set some metrics and some standards. But the last thing I'd like to say to the commission is, what kind of outcome do you want besides transparency? Because it's not all about transparency. It's about privacy rights, it's about the First Amendment, and it's about politics. Okay, people play politics, and you know it with ethics complaints. If free speech is squelched, this commission has failed. If citizens disengage from politics, this commission has failed. If honest political debate is shut down, you have failed. You have to guard against the process being abused and misused for political purposes. Again, the person against whom the complaint is launched is often smeared. If a blogger stops blogging, he loses his audience. The public is less informed and free speech is squelched. We are over-regulating politics and political speech in this country. Free speech is all but dead on college campuses. I have 2 girls that are in college. When I go to their college campus, there's a box that's painted on the sidewalk in a remote part of campus. That's the free speech zone. The rest of the college campus is not a free speech zone. That, in my opinion, that's wrong. In America, I believe we are moving towards a system where only the rich, the crazies, and political professionals will engage in politics. Everybody else is going to be scared off. Engaging in politics is becoming more and more risky, so fewer and fewer people are engaging in it. We're losing the America that I volunteered to defend. So I urge this committee not to be complicit in that. Be courageous. Stand up for the average citizen. Stand up for free speech. Stand up for due process. Stand up for good governance. Promote citizen engagement. Don't let transparency be used as a weapon against citizens, as a weapon against free speech, as a weapon against democracy, and as a weapon against citizen participation in our political system. Thank you for listening to my comments. And by the way, I was very impressed by the discussion that you just had, and clearly you know what you're talking about. And I think the state is well served by having you, somebody like you as the executive secretary.
Thank you very much.
Thank you.
Thank you, Mr. Becker. Thank you for coming to the meeting. Thank you for your service to our country. I applaud some of your recommendations, and I do think that probably some time spent with Mr. Ritter, Ms. Wetzel, and Mr. Lane, showing you some of the metrics that we do have in place already may help with some of your concerns. I appreciate that your charge to us, but please know that we are charged with being within the ambit of the Campaign Finance Act. And but as Commissioner Vice Chair and Commissioner Kathy has said in the past on the record, and you can go back and find it, that we seek to make sure that these complaints are not utilized as weapons, and that they are, in fact, utilized to enforce the Campaign Finance Act. And there are metrics that that Mr. Ritter and Ms. Wetzel and Mr. Lane utilize to make sure that complaints that are not within the purview of the Campaign Finance Act are dismissed administratively. So I think it would probably be time well spent for you to sit down with them. But again, thank you for coming and speaking, and thank you for your service to our country and your continued service by being an advocate of free speech. Are there any other public comments before we adjourn? Okay, and hearing none, I just want to confirm that there's nothing else further, Mr. Ritter, on the agenda. That's correct? That's all I have.
Nope, I think we're done for today, and we'll see everybody on the 13th of December.
Okay. Madam Chairman? Madam
Yes.
Chairman?
Yes.
I would just like to pose the question to Stephan. Are there any more, I know the advisory opinions are to help people and eliminate confusion, and are there any more advisory opinions that y'all are in the process of percolating through some considerations?
Not right now.
Okay.
Of course, we might get one in the next, few weeks or whatever. I do think that we will have two regulations on the agenda proposed for the commission that will relate to this one. That'll answer a couple of the questions that have been asked. But I think that there are no more AOs to be answered. And this is probably the most difficult advisory opinion that we've been asked.
Yes, and I think it's needed for clarity for all sides.
Agreed.
Okay, that's all I had. Thank you.
Sure. Anybody else? Okay. It is 11:09 a.m. We will adjourn the specially called October 5th, 2017 meeting of the Commission. Thank you, everyone.
Great. Thanks, everyone.
Bye.
Thank you.